14th lecture note. The title of this lecture note is Criminal Law Procedure. We are going to look at this in four aspects. The first, principles of criminal procedure. The second, participants in criminal proceedings. The third, evidence and proof. The fourth, criminal case. Let us look at the first aspect, principles of criminal proceedings. Criminal law procedure or criminal procedure is a branch of law that regulates the activities of the court, prosecutor's office, investigation and inquiry bodies in the initiation, investigation and resolution of criminal cases. The main sources of this branch of law in Russia is the Criminal Procedure Code. The purpose of criminal proceedings is as follows. 1. Protection of the rights and legitimate interests of victims of crimes. 2. Protection of the individual from illegal and unjustified charges, conviction, restriction on rights and freedoms. The principles of criminal law procedure include 1. Reasonable time criminal proceedings. 2. Legitimacy. 3. The administration of justice only by an independent court. 4. Respect of honor and dignity. The inviolability of the individual. 5. Competitiveness of the parties, that is, prosecution, defense, and resolution of criminal cases are separated and performed by different persons. The prosecution and equal protection. The court shall not act on any party, being the arbitrator in the process. 6. Presumption of innocence, that is, the accused is considered innocent until his guilt in committing a crime is proved legally and established by a court verdict that has entered into force. The burden of proving guilt lies with the prosecution. Irremediable doubts about guilt are interpreted in favor of the accused. 7. Ensuring the suspect and the accused the right of defense, in some cases at the expense of the state. Let us look at the second aspect, participants in criminal proceedings. Participants in criminal law procedure are subjects who have rights and or obligation in connection with criminal proceedings. The prosecutor supervises the legality of the initiation and investigation of criminal cases, says the indictment, the prosecution in the trial. Investigator excite and investigate criminal cases. The heads of the bodies of investigation and inquiry that control and direct investigation. The victim, person harmed by the crime. The private prosecutor, the applicant in cases of private prosecution. The civil plaintiff, the person who presented a claim for damages and caused by the crime or harm. The defense, the suspect, that is, the person against whom a criminal case is detained or to which is applied a measure of restraint. The defendant, that is, the person against whom the decision on recognition of the accused. Defender, usually a lawyer, along with it can be made public defenders. Cases in the production of the magistrate such, they may be instead of a lawyer. The court. The court is the main participant in the process, considering and resolving a criminal case in a single or collective composition. Most criminal cases are considered by federal courts, some crimes of small and medium gravity by magistrate courts, that is, courts of the subjects of Russian Federation. The proceedings in which are somewhat simplified. In criminal cases involving a number of particularly serious crimes, at the request of the accused, proceedings may be conducted by a jury consisting of a panel of jurors selected by random selection only for the case and deciding questions of fact, and one professional judge deciding questions of law. Other participants, those who do not have an independent procedural interest and or assist justice, a witness, expert, specialist, translator, witness, as well as a person in respect of whom a criminal case has been singled out in separate proceedings in connection with the conclusion of a pre-trial cooperation agreement with them. Let us look at the third aspect, evidence and proof. Evidence in a criminal case is any information on the basis of which a court, prosecutor, investigator, or inquirer in accordance with the procedure established by the Code of Criminal Procedure, establishes the presence or absence of circumstances to prove in criminal proceedings, as well as the other circumstances relevant to the case. Types of evidence. 1. Testimony. That is information provided during the interrogation from the suspect, accused, victim, expert, specialist, witness. 2. Material evidence. That is tools and other means of committing a crime, items that have preserved its traces, items that were targeted by criminal actions. 3. Documents. That is contain information related to the case, recorded in written or otherwise, including protocols of investigative actions and court sessions, conclusions of specialists or expert, documents of people and organization, materials of photos, audio, video recordings, and other media. Proof. Proof is the procedural activity on the collection, verification, and evaluation of evidence in order to establish the following circumstances: the offense, that is time, place, method, and other circumstances of commission; the guilt of the person in commission of a crime; form of guilt and motives; circumstances characterizing the personality of the accused; the nature and extent of the harm caused by the offense; circumstances precluding crime and punishable act; the circumstances softening and aggravating punishment. All evidence is evaluated by the court freely based on the requirements of the law and according to their inner conviction. No type of evidence takes precedence over others. The evidence must meet the requirements of relevance, that is, relationship to circumstances, subject to providing the case; affordability, that is, getting into the manner prescribed by law. For example, obtaining a court permission to search, listening to talks, proper execution of tests, purchases. Reliability, that is, timelessness, lack of distortion, falsification, and altogether sufficiency for the resolution of a specific criminal case. Let us look at the fourth aspect: criminal case. In criminal law procedure, there are pre-trial and judicial proceedings. Pre-trial proceedings include pre-investigation checks of reports of crimes, initiation of a criminal case, and its investigation in the form of an inquiry or preliminary investigation. The result of the investigation, while confirming the charge, the indictment drawn up by the investigator or the act, the inquirer, send the case to the prosecutor for approval. The prosecutor, after examining the case, may return it for further investigation or approve the indictment that is the basis of transfer of business to court. Court proceedings include preparation for trial, preliminary hearings, not required in all cases. For example, it is required when deciding on the measure of restraint, exclusion of evidence, return of the criminal case to the prosecutor. Judicial investigation. The parties, sequentially first the prosecution and then the defense, state its position on the merits of the case and prove it by producing evidence and verification by the court. Pleadings. That is the final statements of the parties, the court of verdict, that is conviction or acquittal, or this other decision to return to the case to the prosecutor. There is a general procedure for judicial review of a criminal case and a special one in one case other than particularly serious cases if the accused agrees with the prosecution and the victim does not object, when only data on the defendant's identity is examined and a guilty verdict is issued, with certain benefits in the imposition of punishment. The term of appeal against the sentence is 10 days from the date of its decision, and for convicted persons in custody from the date of delivery of a copy of the sentence. The verdict comes into force if the parties do not appeal or if it is confirmed by the Court of Appeal. For the World Court, This is the district court. For the district, the judicial board for criminal cases of the court of the subject of the Russian Federation entered into force. Court acts may be appealed further to the court of cassation, the circuit court, fourth judicial board on the criminal case of the Supreme Court of the Russian Federation, and finally the supervisory authority, that is the Presidium of the Supreme Court, the ultimate authority for the review of criminal cases. The appeal can review a criminal case completely, both on factual grounds establishing circumstances proving and on legal grounds, while cassation and supervision can only be carried out if there is a significant violation in the application of this substantive or procedural law. And with that, we come to the end of the 14th lecture. Thanks.